Hello, Dr. Zach. How are you today?
Hello, may I know who I am talking to?
I'm Nazir, Space Law student at Faculty of Law and International Relations from University of Sultan Zainal Abidin. How are you, Dato?
I'm good. What about you?
I'm fine too. May I have your favor, Dato?
Sure, Nazir.
Well, since you are one of the astronauts who joined the mission to walk around the moon together with Alif Armstrong last year, I would like to have a Q&A session for about 15 minutes with you regarding the outer space law for my mooting research.
Oh, I'm glad to hear that. May I know your questions are under what topic?
Actually, I have some questions on the topic of state sovereignty. As we all know, state sovereignty can be described as the right of a state to act independently of other states, subject only to such restrictions as international law impose. However, the term res communis might be confused for me. Could you explain to me in detail about this term?
First thing first, you need to know that beyond the point separating air from space, states agreed to apply the international communism so that no portion of outer space may be appropriated to the sovereignty of individual states. This term refers to territory over which no state has sovereignty and which cannot be appropriated by any state. Hence, it can be said that a state must respect its use by any other state and not do anything that might adversely affect their use of it.
Wow! Your explanation gave me a clear direction for now. Mind to share with me some examples?
One of the significant examples include the high seas, outer space, and the celestial bodies. But the term may also be used to describe legal regimes established by treaty to administer resources common to two or more states, such as an oil field, or perhaps more controversially, a special region like Antarctica.
Dato, since there are some categories of territories which could be classified into four, which is national territories, res nullius, res extra commercium, and the common heritage of mankind, can you describe a little bit regarding this matter?
Sure, Nazir. A brief explanation about national territory can be seen in the situation where the state, or very exceptionally two or more, exercises territorial sovereignty to the exclusion of all others. Furthermore, res nullius can be defined as an area which may be acquired as national territory, where territories which are not under the sovereignty of the recognized subject of international law, but which are capable of being acquired by any state in accordance with the rules of international law governing the acquisition of territory. In other words, they are merely not yet the territory of any state. For the third category, which is res extra commercium, actually is an area which by law are not susceptible of national appropriation, where territories which cannot be made the territory of a state, such as the high seas. Last but not least, the common heritage of mankind is one of the categories of territory where the areas which are not only in themselves not subject to national appropriation in a territorial sense, but the fruits and the resources of which are also deemed to be the property of mankind at large. For instance, territories which constitute the common heritage of mankind and are excluded from national appropriation. Before that, I have one question for you, Nazir. Could you explain the common heritage of mankind from a legal standpoint?
Yeah, sure, Dato. From a legal standpoint, The common heritage of mankind is an evolution of the res communis concept, as previously described. According to the latter, certain areas outside the national jurisdiction may not be appropriate or occupied by any states because they are represent a common concern of all mankind. At the same time, such theory calls for equality of treatment and confer on all states the right to freely explore, use, and exploit the common area concerned and its resources.
Good explanation, Nazir. I would like to add some more. Bear in mind that the common heritage of mankind concept differs from this approach in several ways. It is based on the assumption that certain areas lying outside of national jurisdiction, for reasons of the scientific and commercial value of the resources contained therein, shall be commonly managed by all states on behalf of mankind. Consequently, the common heritage of mankind area cannot be appropriated by a single state or private person. Unlike other communism theory, states are not given the right to freely use and exploit the common area and its resources. Instead, all activities, particularly those aimed at exploiting the area's resources, can be carried out only in accordance with principles and rules established by an international regime. The primary purpose of such a regime is the orderly management of the area and its resources and equitable sharing by all states of the benefits derived therefrom.
Dato', is there any other name for this concept?
Yes, this concept also calls for environmental protection and freedom of scientific investigation within the common heritage of mankind area. Besides, the most controversial aspects of the common heritage of mankind theory are the formulation of the principles and rules constituting the international regime and the way benefits can be shared among all states. Indeed, developed and less developed states hold diverging positions. Nazir, how does state sovereignty affect international law?
Yeah, as for me, Dato', state sovereignty is a concept that states are completely and exclusively controls of all the peoples and property within their territories. State sovereignty also includes the ideas that all the states are equal as state. In other words, despite their different land masses, population size, or financial capabilities, all states, ranging from tiny island to Micronesia to vast expanse of the Russia, have an equal right to function as a state and make decisions about what occurs within their own border. Since all states are equal in this sense, one state does not have the right to interfere with internal affairs of another state. Practically, sovereignty means that one state cannot demand another state take any particular internal action. For example, if Canada did not approve of a Brazilian plan to turn a large section of Brazil's rainforest into an amusement park, the Canadian reaction is limited by Brazil's sovereignty. Canada may meet with the Brazilian government to try to convince them to halt the project. Canada may bring the issue before the United Nations to survey the opinion of the project. Canada may even make politically embracing public campaign in the world media. However, Canada cannot simply tell Brazil to stop the rainforest project and expect Brazil to obey. Under the concept of the sovereignty, no state has the authority to tell another state, however, to control its internal affair. under the concept of state sovereignty, no state has the authority to tell another state how to control its internal affair. Sovereignty both grants and limits power. It gives states complete control over their own territory while restricting the influence that states have on one another. In these examples, sovereignty gives the power to Brazil to ultimately decide what to do with its forest resources and limit the power of Canada to impact this decision. Dato, could you classify what are the 4 features of sovereign state?
The 4 characteristics of a sovereign state can be stipulated where the international law defines sovereign states as having a permanent population, defined territory, one government, and the capacity to enter into relations with other sovereign states. It is also normally understood that a sovereign state is neither dependent or nor subjected to any other power or state.
Dato, I got one last question for you. Mind to share any cases concerning this concept of state sovereignty?
Sure, Nazir. One of the cases concerning this concept can be seen in the issue of sovereignty over Pedra Branca, or known as Pulau Batu Putih, Middle Rocks, and South Ledge between Malaysia and Singapore. On 24 July 2003, Malaysia and Singapore jointly seized the court of a dispute between them by notification of a special agreement signed on 6 February 2003 and which entered into force on 9 May 2003. Under the terms of that special agreement, the parties requested the court to determine whether sovereignty over Pedra Blanca or Pulau Batu Putih, Middle Rocks, and South Ledge belongs to Malaysia or the Republic of Singapore. They agreed in advance to accept the judgment of the court as final and binding on them. In that judgment, the court first indicated that the Sultanate of Johor had original title to Pedra Blanca or Pulau Batu Putih, the granite island on which Horsburgh Lighthouse stands at it. It concluded, however, that when this dispute crystallized, title had passed to Singapore, as attested to by the conduct of the parties, in particular certain acts performed by Singapore and the failure of Malaysia to react to the conduct of Singapore. The court subsequently awarded sovereignty over Pedra Branca or Pulau Batu Putih to Singapore. As for Middle Rocks, a maritime feature consisting of several rocks permanently above water, the court observed that the particular circumstances which had led it to find that sovereignty over Pedra Branca rested with Singapore clearly did not apply to Middle Rocks. It therefore found that Malaysia, as the successor to the Sultan of Johor, should be considered to have retained the original title to Middle Rocks. Finally, with respect to the law type elevation South Ledge, the court noted that it fell within the apparently overlapping territorial waters generated by Pedra Branca and by Middle Rocks. Recalling that it had not been mandated by the parties to delimit their territorial waters, the court concluded that sovereignty over South Ledge belongs to the state in whose territorial waters it lies.
Dato, how does state sovereignty affect human rights?
State sovereignty, in short, is the idea that each nation-state should not interfere in the affairs of another nation-state, and in turn should be free from interference by other nation-states, that states have supreme authority and independence. In the aftermath of the Two World War, the UN Charter strengthened the existing international system based on the sovereign equality of the states, so as to protect states from unwanted violent intervention from antagonistic its external forces, and by extension protect the human rights of citizens. However, State sovereignty can also greatly hinder global enforcement and implementation of human rights. Sovereign states not only are creating the international norms for the protection of human rights, but also are determining the process of their implementation or non-implementation according to their sovereign will. Effectively, respecting state sovereignty means that any tangible human rights enforcement mechanism must come from states' own domestic legal system, meaning in turn that in cases where a state ignores or itself carries out human rights abuse, the principle of state sovereignty comes into conflict with any possibility for resolution. When human rights are framed as more inviolable than state sovereignty, the human rights regime can claim humanitarian grounds to impinge on state sovereignty and put the state's treatment of its citizens under external scrutiny. Popovsky argues that discourse surrounding the balance between state sovereignty and human rights is shifting in favor of increasing permissiveness towards cross-border action to protect human rights. In practice, however, the supposed primacy of human rights over state sovereignty is rarely applied, where the Security Council rarely comes to the agreement that humanitarian intervention is justified or necessary.
Thank you, Dato', for the clarification. It gives me a lot of information, and I think it is my passion to further my study in this field. Again, thank you so much, and I hope that you are doing well.
It's my pleasure, Nazir. Good luck in the future.